Good morning, everybody. This is Stanley Okoro from Atlanta, Georgia. It's 12 noon in the East Coast. Welcome to our number 10 ANPA financial webinar. Today, we have an exciting presentation, but we're going to be talking about domestic and international estate planning in challenging times. Challenging times it is. Today is Saturday, November 7th. This is our number 10th webinar. Before we start, I would like to introduce our national president, Dr. Chris Okunseri, to kind of give us an overview what ANPA does, who's ANPA, and some of the benefits of ANPA membership. Chris?
Thank you, Dr. Stanley Okoro. Before I dive deep into who we are, what we do, I want to quickly, once again, use this opportunity to thank the organizers, you, Stanley, for doing this, and the panelists. You know, this is a lot of work. I recognize it. The members of ANPA and the board recognizes the amount of work that goes into this. So quite honestly, we appreciate what you guys are doing, and I think the members really support this idea. With that being said, just a quick reminder of members and those who are on this call. We are a 501c3 organization. We represent, well over 4,000 physicians, dentists, and allied health professionals who are of Nigerian birth or ethnicity. We're pretty much an organization that engages in professional development as part of our members' benefits. We are very much involved with finding opportunities for leadership. We are really interested in getting practice referrals among the network of members. We also love the opportunity to network amongst ourselves. We have all the way here in America. It's always good to keep our network going. We also look forward and engage in supporting our members in times of need and in times of celebrations. Again, it's part of the networking, it's highly connected, and we engage in a very robust medical mission where members actually volunteer to participate in a medical mission in Nigeria. We have different forms of medical mission, which, as members, you are pretty much aware, certified, ANPA certified mission, and ANPA other types of mission. We really take on this challenge and continue to do well at this point. So with that being said, I would open this up to the panelists and again, continue to thank them for their generosity of time to, educate all of us about what all of this is about for us and would help us improve ourselves. Thank you very much.
Thank you very much, Dr. Okunseri, our national president, for introducing ANPA in this forum. Before we start, I just want to give a ANPA disclaimer. Please note that the materials presented at all ANPA webinar is for general educational informational purpose only and is solely the opinion of the presenter. No webinar is intended to provide personalized financial or legal advice. It is left to the discretion and judgment and is the sole responsibility of each attendee to determine what is necessary for his or her own practice. Neither the speaker or ANPA can be held responsible for the materials, opinions, or any inadvertent error or omission in the preparation and presentation of the material. Furthermore, nothing in the material should be construed as an endorsement by ANPA. With that, I'm going to hand this over to our presenters. Eni is the founder and CEO of World RX for Doctors. He has been a very strong supporter of ANPA for so many years, and he's going to give us an overview of what we're talking about today, and then he will then present Brian Raftery, who's with Danton's LL.M. Eni?
Stanley, thank you very much. Thank you, Stanley. Stanley has disposed or dispensed with the disclaimers. He skipped my disclaimer page, and I think we go through this all the time. I am going to adopt the same disclaimers that he has. We're going to provide you sound counsel and our best advice and our best information that you can act on at all times. welcome to all of you to another in the webinar series that ANPA provides to its members as a benefit of membership. Hopefully, in the times that we have provided you the experts on our faculty, you have found them to be worthwhile and worthy of your time. What we hope we do here is continue to arm you with financial intelligence, to continue to educate you and help you make sound, intelligent financial decisions to support what you have accomplished in your lives. So today, Stanley, move to the next slide, please. Today, we are going to address estate planning. Those of you who have been on these calls in the past have seen this pie, and I'll call it the pie. And as you can see, we consider the pie an imperative to best practices in wealth management, in financial planning, in affluence, and everything that you're doing that has to do with your finances. It is about assembling a team in estate planning, a team in tax planning, insurance planning, income planning, investment planning. What people tend to do is they think that if they have a CPA that does their tax preparation, that immediately implies tax planning. That is not accurate. What people also think is that when they have an investment professional that they work with, that incorporates all the aspects of their financial lives that are truly an imperative. Well, my friends, let me tell you this, that is not the case. Tax preparation is not tax planning. And I think that over the months that we've gone through this and over the years, those of you who have been a part of our firm as clients know that because of the importance of each of these pieces of the pie, we have and we bring and we recommend, most importantly, that you identify specialists as part of your team that not only specialize in each of these areas, but work together to provide you the services of a coordinated team in a holistic manner. So today we're going to talk about estate planning. In the last 3 months, give or take, since what we call the last few months of the year, we've touched on tax planning particularly because we believe that that is so important. 2020 has been quite a year. And what we want to make sure happens with the end of the year is that you minimize as much taxes as you can in everything that you're doing as you earn whatever income you earn in 2020. And so from a planning standpoint, it's important that you do that. But today we're going to talk about estate planning, and that's why we have Brian here. Brian Raftery is a partner at Danton. And for those of you who may not know this, Danton's is the largest law firm in the world. Brian is the head of the Trust and Estate Planning Group at Danton. He's also the chairperson and co-leader for the Global Private Practice Group at Danton. Brian is a CPA and he's an attorney. So you've got a combination there. His focus is on international and domestic estate planning, hence the title. He focuses on creditor protection, asset protection trusts, insurance planning, pre-immigration and post-immigration planning, which I thought would be of interest to a number of us here. Brian has received significant recognition as a super lawyer and top attorney in estate planning in the country. Since 2014, Brian has been recognized as a super lawyer, one of the nation's super lawyers. Brian has been recognized as one of the best lawyers in America for trusts and estates which is the subject that we're dealing with. This is our commitment. We're going to bring you the best. So Brian has been published in the New York Law Journal. He's been interviewed by news outlets, CNN, CNBC. Brian's membership and leadership roles have included the American Institute of CPAs, the American Academy of Attorneys and CPAs, and he's actually been one of, the past president of the New York chapter. Brian is a practitioner in the area of trusts, estates, and wealth preservation with a global focus. So, my friends, I'm going to bring to you my good friend, Brian Raftery. You're on, my friend.
Thank you very much, Andy, and thank you very much for the kind introduction. I wish you could give that introduction to my 3 teenage daughters, because maybe they might be slightly impressed with something that they might find in that information. But to me, I'm just dad, and that's it. But again, thank you, Andy, for the kind introduction. Thank you very much, everybody, for the opportunity to speak with you today. I appreciate your time. I know you're all very busy, so I hope that the time we spend together you find valuable. And of course, if there's any follow-up, my contact information is available for anyone. If anyone wishes to follow up subsequent to this presentation, please feel free to do so. So with regard to my background, and he was very kind to let you know about my background, who am I and why am I here and why am I speaking to you today? I won't go through everything that any of you already had gone through, but again, I am a trust and estates attorney. I'm a partner at the law firm of Danton's. Danton's is a worldwide law firm with offices on every continent except Antarctica. If there was ever a demand for legal services in Antarctica, I know our CEO would send one of us there to take care of that, but currently that's just not the case. With regard to the type of work that I do and taking into account my CPA background, I don't practice as a CPA. I did at one point with the accounting firm of KPMG, but I'm an attorney who happens to be a CPA. And with regard to the clients that I have, I've been very fortunate in my career. I have domestic and international clients that span the gamuts of wealth, that span states and countries and continents. And it's been a very interesting ride so far. But with regard to the clients that I do work with, medical and dental professionals, high net worth individuals in the United States and internationally, hedge fund principals, private equity principals, business owners, real estate investors, athletes, television personalities, and also we do a great deal of pro bono work as well. So with regard to lower income individuals who may not be able to afford the services of an attorney, we assist those clients with regard to the preparation of their estate planning documents. In addition, with regard to deploying troops, if they may be going overseas, we assist on a pro bono basis with regard to their estate planning as well, to ensure that while they're doing their jobs, the least that we can do is to assist them, give them some peace of mind that their estate planning documents are in place. So next, please, Stanley. So with regard to estate planning, very often there can be some misconceptions about estate planning. So I've had new clients come to me saying, Brian, I don't have a will, I don't have an estate plan. We really need to work on one very quickly because of some life event. Maybe they've just had a child, maybe a close family relative has passed, and they've seen the difficulties when the documentation isn't in place. But the threshold question, true or false, I don't have a will, so I don't have an estate plan. The answer? That's false. Everyone has an estate plan, whether or not that you have a will or other estate planning documents in place. As you can imagine, individuals pass away each year not having a will. So everyone has an estate plan. It's a matter of whether that estate plan is one that you work on with your advisors, such as NEA, your attorney, your CPA, or alternatively, your estate plan will be the one that the government will give to you. If someone passes away without a will, they did not direct in their last will and testament where their assets would have gone upon their passing. So guess what? The government makes that determination, has a set of laws that you may or may not agree with. I'll give you an example. In the state of New York, where my office is, if an individual passes away with assets in their names, one might think intuitively, if they didn't have a will, all the assets would go to the spouse, and then subsequent to the spouse's passing, assets would go down to the children. That's not the way it happens. In a state like New York, when one passes away without a will, half of your assets go to your spouse, half of your assets go to your children. Now, if you have, for example, young children, ages 8, 6, and 4, those 3 children now have half of the assets. You haven't controlled the estate tax that will be hit those assets, our inheritance tax. And unfortunately, your plan is now the state's plan. I haven't met anyone along the political spectrum of all of my clients yet who have said, hey, let's let the government sort that out and make the decisions for me. So with regard to the 4 basic estate planning documents that everyone needs, no matter what wealth level, whether you're worth $100 or $100 million, I call these 4 documents the foundational 4. And these documents are the last will and testament, a durable power of attorney, a healthcare proxy, and a living will / healthcare directive. Now, certainly with the audience that we have on this particular call, you may be able to tell me about more about the healthcare proxy and living will than I can tell you, but I can tell you from the legal side of things how they play into an estate plan. So with regard to the last will and testament, the last will and testament is a roadmap or an instruction manual of what to do after someone passes away. So I'll use myself as an example, because I hate talking about other people dying. But when I die someday, my will is the instruction manual to everyone saying what happens. A will basically does 2 things. A will names people to important positions and disposes of your assets. So with regard to naming people to important positions, the most important position that you can name in a last will and testament is if both parents of a minor child have passed, who would be the guardian of that minor child? Who would the minor child live with on a day-to-day basis? Who would be acting in the parents' roles for the minor child or minor children? The most important designation in a will, guardian for minor child and backup guardian. If you don't name who the guardian and backup guardian are, and heaven forbid, something happens to both parents, the government is choosing who the guardian is. I haven't met anyone yet who wishes to have the government in that position of making that decision. The executor of a will, in some states called a personal representative. The executor's job is to execute a plan that's in the will. Someone has to be the point person for my estate when I die. So when I, Brian Raftery, die, the assets that I own are in essence suspended in the estate of Brian Raftery until those assets are distributed pursuant to the terms of my will. So with regard to the executor, someone has to be the point person for my estate. Someone has to execute the plan that's in my will. That's why we call this individual the executor. So for example, when I die, someone has to cancel my credit card. Someone has to file my last income tax return. Someone has to gather my assets. Someone has to ensure that the assets reach the parties that I've designated in my will. The executor has the authority to do all of these things, but the executor can't change the terms of my will. So for example, if I've in my will made a specific request to the American Cancer Society of $10,000, the executor can't decide to give $7,000 or $20,000. The executor's job is to fulfill my directives that I've provided in my last will and testament. They can't deviate from those directives, but someone has to be in charge. Someone has to have the legal authority. So the executor of the will, guardians for minor children, and trustees of children's protective trusts. For example, if you're leaving assets to your children down the line and they're younger, or a child may have special needs, or may have special needs, I should say. These types of trust arrangements, which I'll get to in a bit more depth a little bit later in the presentation, these trusts have to be run by someone who's going to be watching over these trusts and ensuring that the intent of the trust is fulfilled. These are trustees. So again, when we look at this group of fiduciaries, guardians for minor children, an executor who has a short-term job of ensuring that the will is implemented, and trustees who can have a much longer-term job of administering a trust for the benefit of the stated beneficiaries, whether it's a spouse, a child, or whoever it may be. These fiduciary positions are very important, and the will appoints these different fiduciaries. In addition, as I noted, a will disposes of assets and can do so in a very tax-efficient way to ensure not only protections that I'll discuss in a bit with regard to the protections that trusts provide, but also ensure that as much in taxes is saved, because our biggest single tax in this country right now at the federal level is the estate tax. The estate tax currently has a rate of 40%, that's 40. And if it looks like we'll have a new administration, that new administration wishes to increase the tax rate up to 50%. Many states have their own state estate taxes, like Illinois New York, Connecticut, and the state estate taxes are anywhere between 12 and 16%. So when you take all of these taxes together and you're adding what may be a 50% federal estate tax to, if you happen to live in a state that has a state tax, another 12 to 16%, there's a silent partner that each of you have. And that silent partner, with regard to your wealth creation, with regard to all the hard work that you've put into your careers and all the education and all the training, that's the government. And they may indeed, depending upon how you plan, look to ultimately take over half of your assets with regard to the estate tax system that we currently have in place. So in addition, with regard to a last will and testament, there are specific bequests. If you might wish to make specific bequests to a niece, a nephew, a charity, a friend. In addition, you can also have charitable bequests, and any assets passing to a charity are exempt from estate taxes. So you'll find, for example, with regard to the very, very wealthy families, they might, for example, have, if they're a billionaire family, might have $200 million go to a private foundation, a charitable foundation, with the idea that that $200 million will go to the foundation free of any estate taxes and is exempt from estate taxes. So the next of the foundational 4 documents, and then the next 3 of the foundational 4 documents, in addition to the will that I'll be speaking about, have a different character to them. The will, my will, only takes effect when I die. It is prospective and does nothing while I'm alive. Even if I'm in a coma, even if I'm incapacitated, my will does nothing until I die. But if I am ill, if I am incapacitated and I can't make my own decisions, the 3 documents that I'm about to discuss assist the family and the individual as well with regard to managing the situation. So for example, a durable power of attorney is a document in which you appoint someone to make financial and business decisions for you, if you're not able to do so for yourself. So if I'm out on a bike ride and I get clipped by a cab in New York City and I'm incapacitated, my will, but it's still alive, my will doesn't do a thing. Not a thing, it doesn't come into effect until I die. But who is watching over my IRA? My wife doesn't have the automatic right to watch over my IRA. I don't have the automatic right to watch over hers and change the investment mix and change withdrawals. So with regard, for example, to my IRA or 401k plan or other retirement plan, if I haven't designated, for example, my wife as my agent in my durable power of attorney, she would actually have to go to court to be named guardian of my property. And then the courts become involved with regard to decisions, with regard to reporting, with regard to other issues that my family would likely just prefer that the court not be involved. So a durable power of attorney precludes the courts getting involved in our private affairs. It allows an agent to be at the ready immediately upon my incapacity. In addition, if my wife and I are in an Uber car and it's in a car accident, once we all start taking Ubers again, I have a backup agent under my durable power of attorney. So with regard to the healthcare proxy, a healthcare proxy, I'm sure almost all of you know, is a document in which you designate someone to make healthcare decisions for you if you're not able to do so for yourself. And the idea is that we look to avoid the courts or the government becoming involved. And if I don't have a healthcare proxy and my wife and I are both injured, someone would have to go to court to be named guardian of my person, not of my property. That's for the durable power of attorney when one isn't executed by a client. But with regard to a healthcare proxy, if I have a healthcare proxy, we can avoid the court involvement. I can designate, for example, my wife as my healthcare agent, my sister as my backup healthcare agent, and you can name as many successors as you may wish, but we always want to have at least one healthcare agent and one backup healthcare agent to avoid government involvement, to avoid outside involvement, and to ensure that the people that I would choose to make healthcare decisions for me are indeed making those decisions. So with regard to the final of the foundational 4, I call them the Fantastic 4 documents, but that's already taken up by Marvel Comics. But the foundational 4 documents, the living will. So the living will is an advanced directive for healthcare. My clients tend to call it, for lack of a better term, and I'm sure everyone on this call can come up with a much better term than what my other clients refer to the document as, but they very often will call it the pull the plug document. So with regard to the living will that I'm sure you're familiar with already, a living will is a document in which you can make end-of-life decisions. So for example, in my living will, I say in the event that I'm in an incurable and irreversible medical condition with no hope of recovery, I don't wish to be kept alive on tube feeding, mechanical respiration, artificial nutrition, hydration, etc., if it simply prolongs the process of my dying. In addition, in a living will, you can make organ donation decisions. Some individuals do not wish to be organ donors. It's a personal choice, and they can choose that within their living will. Other clients do wish to be organ donors, but they might wish to specify some parameters. I've had clients who say, yes, they'll be organ donors, but only for transplant purposes, if their organs can be used to facilitate a better life and better health for another human being. Other clients have decided that they would donate their organs for almost any purpose, whether it's transplant, use in a medical school, use for medical research. So it's all that individual's choice, but those choices can be put into a living will. And as a practical matter, in a non-medical sense, living wills are helpful in two primary situations. Number one, if you have a living will, all of your relatives and those close to you know what your decisions are. There's a sense of peace in following your decisions instead of guessing, wondering what would, for example, again, using me dying, what would Brian have wanted if he's on a respirator? Do we keep him on the respirator? At least if I have made a directive, a healthcare directive, telling people what I want, number one, it's legally enforceable. Number two, people have a sense of peace about decisions that have to be made. Number two, with regard to situations of family conflict, I've seen this before where, as an example, we have an older mother who might be on a respirator, adult son says, mom's not coming back, she wouldn't want to live this way. And adult daughter says, who are you to play God, and pull her off of the machinery that is otherwise keeping her alive right now. If indeed, in my situation that I've seen before, the plug is pulled, the adult daughter may never again speak to the adult son saying, in essence, you killed mom, and there can be a family breach if mom didn't have a living will. Alternatively, in my hypothetical, if the mother did have a living will, then while the adult daughter may not agree with mother's decision, at least the adult daughter can't blame the adult son. And perhaps then rifts in the family will not occur, and the family can continue on having the peace of mind of knowing what mom's wishes were in the living will. And we can all, in essence, almost put ourselves in the place of that mother that I was using in my story. What if other family members end up not speaking with each other because of certain decisions that were made? If you make your decisions, everyone can be in general at peace, and at least they can't blame each other for those decisions. So it was Benjamin Franklin in the 1700s that said there are two certainties in life: death and taxes. And this discussion is kind of bringing both of those things together, because the estate tax and the inheritance tax occurs upon death. And since both taxes and death, pursuant to Ben Franklin's statement, are the certainties in life, this is where they all come together. So when you think of the United States and its different tax systems, think of all the different taxes that you pay. If you earn income from a salary, you pay ordinary income tax. If you sell something at a profit, you pay a capital gains tax. If you own real estate, you pay real estate taxes. If you buy something, you pay a sales tax. It's very taxing. But all of these different taxes, whether it's income tax, capital gains tax, there are different rules with regard to these taxes. And the same is the case with another category of taxes that we have, our estate tax system, which is national. And in essence, they are our inheritance taxes. What's the difference between estate taxes and inheritance taxes? I mentioned earlier that when I die, there's, in essence, almost a fictional suspense of my assets in the estate of Brian Raftery. Under an official estate tax, that estate, after I die, is taxed with money taken out of it, with the remaining assets going to my beneficiaries. That's officially an estate tax. An inheritance tax is different in how it operates, but at the end of the day, it still results in your beneficiaries getting less money. So an inheritance tax, in essence, ignores the estate. And when the beneficiaries receive the assets, they are the ones cutting the checks to pay the inheritance tax. That's the official difference between an estate tax, where the beneficiaries aren't cutting the checks, they just get less, because my estate has to pay a tax, and an inheritance tax, where the beneficiaries themselves are cutting checks, thereby getting less. In certain respect, it's 6 of one, half dozen of another, but that's officially how the taxes are delineated between the state and inheritance taxes. So with regard to the silent partner that I mentioned, and bullet point number 2, you have that silent partner of up to 50% or more of your assets with regard to estate taxes. Now, with regard to estate taxes, how does it work? I am a US citizen, my wife's a US citizen, we have 3 US citizen daughters. When I die someday, if my assets pass to my US citizen wife, those assets pursuant to the terms of my will passing to my wife qualify for what's called the unlimited marital deduction from the estate tax. If I had $10 billion, which I don't, but if I did, if I had $10 billion and I leave it all to my US citizen wife, there's no estate taxes. The issue is the estate tax hits when she then leaves the assets downward to the children. Now, with regard to a situation if my wife was not a US citizen, the unlimited marital deduction from our gift and our estate tax regime doesn't qualify or isn't available for a non-US citizen spouse. So if my spouse was not a US citizen and I look to pass assets to her, the government, the federal government and our tax code treats that as assets passing down in essence to almost a friend or a child or what have you. You don't get that unlimited marital deduction if you don't have the appropriate provisions in your will. If one has a non-citizen spouse, you can still, if you have the appropriate estate planning in place, have the unlimited marital deduction through what is called by its acronym a QDOT, a qualified domestic trust. So if in my will, I have my assets passing to, for my non-US citizen spouse, a qualified domestic trust of which she can be a trustee and she must receive all of the income and has use of the principal as well, we can take a big tax bill off the table right off the bat by having the assets for a non-citizen spouse passed to a qualified domestic trust. Now, this passing of assets on my death also applies with regard to lifetime gifts. 100 years ago, when the United States at the federal level first instituted an estate tax, what people would do is on their deathbeds, if they realized that things weren't looking good and things are looking grim and they were going to pass away, a few hours before they died, they say, hey, look, if I die with all these assets, there's an estate tax. I'm going to give them all to my relatives right now. I'm going to gift them away, hence no taxes. Then a few hours later, they die and they've avoided the estate tax. The government picked up on that after several decades. It took that long. And what the government instituted was a more comprehensive transfer tax system that included a new gift tax. So the idea is that if I'm on my deathbed, I can't just start giving assets away and then die a few hours later avoiding the estate tax. So the gift tax and the estate tax both apply to any gratuitous transfers that you make either during your life for the gift tax or on your death for the estate tax. And the government provides an exemption from these gift and estate taxes, amount that you can give away free of gift and estate taxes. Currently, we have the most generous exemption we've ever had since the institution of the estate tax. We have an $11,580,000 exemption from the gift and the estate tax. What does that mean? That means during my life, I can give away, or at my death, I can die with that amount of assets that can be protected from gift and estate taxes. And here's how it works with regard to the different exemptions that we have. Primary exemptions, there's the first exemption during my lifetime is what's called the annual exclusion. I can give $15,000 away to as many people as I wish. So I give NEA $15,000, each of his children $15,000, I give Stanley $15,000 every single year, no gift tax ramifications whatsoever. I give NEA $15,000 today, and then tomorrow, let's say I gave him $1 million. I've used up 2020's $15,000 annual exclusion for the gift tax, and by giving NEA $1 million tomorrow, my $11,580,000 exemption goes down to $10,580,000. If I die in December, I have a remaining $10,580,000 of exemption to cover the assets that are in my estate. Now, why is this of particular importance with regard to the estate tax? The estate tax has a very high exemption right now and is at a 40% rate. With a new administration coming into office, and I think AP announced that that will be the case. Officially, they announced it. I think we all saw it coming. But with regard to changes in tax law that could occur next year, this very generous $11.58 million exemption could go all the way down to $3 million. That's a very, very big difference. And the tax rate, as I mentioned, could go from the current 40% at the federal level up to 50%. So what are clients doing right now while they have this big exemption available to them? They're using it to gift into trusts. For example, if you had two spouses with $22 million in total, each spouse has an $11,580,000 exemption. Spouse one creates a trust for spouse two of $11 million. Spouse two creates a trust for spouse one for $11 million to keep the assets in their generation, and they've sheltered the full $22 million from all future estate taxes, and they've grandfathered in the benefits of these trusts. Alternatively, if that same $22 million couple did not make any gifts. And next year we have a new tax regime in place with a $3 million exemption. And let's say, heaven forbid, both spouses passed away. You take that $22 million, you subtract out $6 million, $3 million each for two spouses with regard to their exemption. Then you get to a $16 million taxable estate where the federal government takes half of it, $8 million. Big difference between what would have happened in 2020 and what, potentially speaking, with a new administration can happen in 2021. And that's why for so many of our clients, these last 2 months of the year are critical, because we're using these big exemptions while we have them. It is a use it or lose it proposition if indeed they do change the exemptions pursuant to new tax law next year. With regard to discussions about trusts, I've had clients come in and begin immediately speaking about trusts, because I'm a trust and estates attorney. And I asked them, do you understand what a trust is? Almost everyone has heard of trusts, but very few people have actually worked with them. And even those who work with them aren't exactly 100% sure of how they work and what they're really working with. Trusts are an English common law concept that we have in the United States, because the United States in its current form began as English colonies. So you'll find trusts in Australia and the United States. You'll find in certain other countries that have had an English influence. But for example, you won't find trusts in Italy, where there's a Napoleonic civil law construct. They don't have trusts, and as an example, continental Europe and many other countries. There's no concept of it, and it's not in law. But here in the United States, we do have trusts. And the way I explain what a trust is through an analogy to a corporation, because trusts are key to so much of the estate planning that we do, and can provide so many protections for a spouse, for children. I always like to explain foundationally, what is a trust? So through that analogy and explaining what a trust is, analogizing it to a corporation, in this chart that's currently on the screen, a corporation has certain attributes to it. I'm not a corporation, you're not a corporation, but you can create a corporation. A corporation is a freestanding entity. It has a president or a CEO that runs it. It has a set of bylaws, rules, and regulations regulating that corporation. A corporation can own any type of asset. It can own intellectual property, real estate. It can own cash, stocks, bonds, it can own anything. At the end of the day, the corporation is supposed to benefit shareholders. And why do people use corporations? Because they're protected, right? The shareholders, for example, can't be sued for the operations of the corporation. That's why we use corporations and LLCs, limited liability companies, LLPs, limited liability partnerships, etc. So looking at a trust is more of a private, family-oriented entity. And to go through the analogy, I'm not a trust, you're not a trust, but you can create a trust. You can create a trust while you're alive, like the trust that I was mentioning before that spouses can create for each other. Or you can say in your will, after I die, here's my directive, create trust like a QDOT, qualified domestic trust, for the benefit of my non-citizen spouse, so that we can avoid a 50% or more estate tax hit when assets pass for my spouse's benefit. Protective trust for children. You can say in your will, after I pass away, create trust for the benefit of my children. But a trust is treated as a freestanding entity, just like a corporation is. Instead of having a president or a CEO like a corporation might, a trust has one or more trustees running the show for the trust. Instead of having bylaws, rules, and regulations like a corporation has, a trust has a set of trust provisions saying what the trustee can and can't do. Much like a corporation, a trust can own any type of asset. Intellectual property, it can own corporations, it can own stock, bonds, cash, real estate. A trust can own anything. And at the end of the day, instead of having shareholders, a trust has one or more beneficiaries that I might designate. And why do we use trusts? Because they are protective and they provide privacy. The properly crafted trust, in addition to providing for a much better tax situation, like in the QDOT that I mentioned, when my wife and I, in our wills, we have trusts for our children with regard to the assets that we die owning. Those trusts also provide our children with creditor protection from lawsuits with regard to the inheritance they receive, divorce protection, so assets within that trust don't get divided in the event of that a child gets married and subsequently divorced. And in addition, the assets in these trusts, because trusts don't die like individuals do, the assets in these trusts can avoid generations of estate taxes when they pass the assets from children down to grandchildren, down to great-grandchildren. Now what is, and by the way, this, as you can see, this is not an electoral map. There are all different types of colors in it. But the most effective type of trust is a trust that can last forever. If trusts are so wonderful, wouldn't it be nice to have a trust that we refer to as a dynasty trust that literally can last forever? Along with the original English common law concept of a trust. And how did it start? Just very quickly, a tiny little history lesson. If an English knight was going to fight in some foreign war, they take their bag of gold, give it to their neighbor, saying, I'm trusting you to take care of my friend here. You're, in essence, the trustee over this bag of gold. I'm hoping to come back, but if I don't, make sure everything is taken care of. And that idea of one party trusting another party to do the right thing pursuant to their directives, how trust began. It's become more formalized over the hundreds of years that they've been around. But the King of England saw these trusts as so effective and so protective, especially in a tax context. He instituted what we still have in most states of the United States to this day. It's called the rule against perpetuities, or the rule against perpetual trusts. The king basically said, hey, look, these trusts, okay, you can keep them for a certain period of time, but they can't last forever. They're too good. I don't like them. I can't tax them enough. So you will have a lifespan with regard to how long assets can be held in consecutive trusts for spouse, kids, grandkids, great-grandkids. It's a very complicated law, the bane of all law students, but it's about 90 to 100 years that assets in a state, for example, I'll use the state that I practice, primarily in New York. That sounds like a long time, but you're all medical professionals. Think of a child born today in reasonably good health with the medical technology and your good care that child would have. The child will likely reach their 90s. So if a trust in a state like New York or other states can only last for about 90 years, you're really only getting one generation of benefit. Dynasty trusts can be created in states that have changed that old English common law rule against perpetuities or rule against perpetual trusts. What are the atypical states that have terrific trust law, like very good corporate law, for example? Delaware. Delaware is a dynasty trust state. We have people who reside in other states creating trusts that are Delaware-based so that trust can last forever, and create a dynasty trust with the family dynastic wealth, avoiding a 50 or potentially speaking 62% estate tax at each generational shift. Guess what? The Rockefellers, guess where their money is? It's in trust. Why will you find certain Rockefeller great-great-great-grandchildren not getting prenuptial agreements? They don't need them. Their assets are held in trust. So when we look at states like Delaware, Nevada, South Dakota, Alaska, these states are looking to attract business, trust business, and they've gotten rid of their rule against perpetuities, rule against perpetual trusts, and you can have dynasty trusts in these types of states. And with regard to the planning that I mentioned, using these big exemptions while they last, because these big exemptions are going away. It's either next year because of politics and new tax law, or these big exemptions are set to automatically sunset at the end of 2025 under existing tax law, even if nothing changed. So these big exemptions are going away. It's just a matter of time. But we are creating trust and dynasty trust jurisdictions with these $11 million gifts, starting off with over $23 million that will never be subject to estate tax again. So the protections provided by dynasty trust, which we've already touched on, professional management protection. For example, you can have your advisor, NEA, for example, or a professional corporate trust company, in addition to NEA and a good CPA, assist with regard to the management of the assets. Estate tax and inheritance tax protection. We spoke about how a trust doesn't die. An individual does. So if the assets are held in trust, the assets can pass down through the generations, and with the dynasty trust, literally forever until the money runs out, so that you're avoiding that 60% hit down the line. Creditor protection. My wife and I have 3 daughters. When we both pass, each daughter will get 1/3 in a protective trust. Even if they're older and more mature, hopefully they won't get their inheritance anytime soon. That means something very bad has befallen my wife and me. But if, for example, I would say to myself, well, my daughter's, if she, which they're teenagers, but if she's over the age of 35, I would give her the money. But I'm not so concerned about her. I'm concerned about everyone else out there. If I give her inheritance outright, if she's the age of 35 or over, as an example, she could still get divorced after the age of 35, and that inheritance can be divided. She can still get sued because of a car accident, or if she became a physician, get sued over the age of 35. She will pass away someday owning those assets that would be subject to estate tax. So the alternative is to leave assets in a trust, for example, for my daughter's benefit, whereby they become the primary trustee of their own trust at the age of 35, instead of receiving all of the assets outright. Then we're having our cake and eating it too, in the sense that the child is in charge of their own destiny. They're in charge of their own trust. In essence, they're acting as, using my earlier analogy, the president of their own corporation. They don't have to go hat in hand asking some other trustee for money to pay for health, education, maintenance, or support needs. And they get all these protections that we want the children to have. So with regard to creditor protection, the assets that I leave to my children that are within trust are protected from their creditors in the event of a lawsuit. The assets in a trust are protected from being divided in the event of a divorce because such assets are considered separate property under divorce law, not marital property that gets divided. Separate property doesn't get divided, marital property does. So trusts keep separate property separate. You can have income tax protections because a trust is a taxpayer. After I die, the trust would be a taxpayer, much like an individual is. And with regard to the trust, if it had, for example, my daughter, but also her children as beneficiaries, the trust can make distributions to the children of income so that the income is no longer in the trust and taxed at the trust level. And maybe it's subject to income tax at much, much lower levels in my grandchildren's hands. So you can have income tax planning with trusts as well. And privacy protections. Privacy can be a big deal, and it seems very hard to have right now just because of internet and it seems like everything is public. But trust can help preserve privacy so that it's much, much more difficult, if not impossible, to find out about the family wealth. So with regard to the protective dynasty trust for multiple generations that I was just speaking about, this is just a little pictorial representation. I guess I included three rows and 3 arrows downward because of my 3 children. But the parents' assets can pass down into separate lifetime protective trusts eventually for the benefit of the kids that will ultimately pass on to separate protective trusts for the benefit of grandkids that will pass on for protective trust for the benefit of great-grandchildren down the line with successive beneficiaries until either the money runs out or the family runs out. With regard to life insurance, when I speak to clients about life insurance, I'm a lawyer, so we don't engage in the actual providing of policies to any clients, but we do talk about protecting life insurance from estate taxes. When I mention this to clients, they initially say, well, hey, isn't life insurance tax-free? As I mentioned earlier in the call, we have lots of different taxes. Life insurance is income tax-free to the recipient, but it is subject to estate taxes if, for example, I, as the person who's insured under the policy, and when I die, it pays out $5 million, whatever the amount might be. If I own the policy, it's an asset of my estate. Everything that I own, no matter where in the world those assets are. If I own a horse farm in Australia, if I own a building in Nigeria, if I own stock in a non-US corporation, everything I own, including life insurance policies, is subject to the estate tax. When I say everything, I mean everything. Jewelry, artwork, homes, clothing, my socks, literally everything that you own upon your passing is subject to the estate tax. And how does the estate tax apply? The estate tax looks to the fair market value of your assets on the date of your death. What does the government, what does the IRS see as the fair market value of a life insurance policy that you die owning? If I die owning a life insurance policy on my life that's worth $5 million, that's $5 million of assets in my estate. Let's say we do have that big change in the estate tax exemption. It goes down to $3 million next year. The $5 million policy alone, without any of my other assets, is going to cause at least a $1 million estate tax to hit. How do we avoid all estate taxes on all life insurance? They're all different types of trusts, but one particular and specific type of trust that we use quite often is a life insurance trust. A life insurance trust is a trust that's created to own life insurance policies. I don't like to remind my wife and 3 daughters about this very much, but I have millions of dollars of life insurance. And I don't like to remind them for the obvious reasons. That's a joke, but with regard to the life insurance, I don't own any of the policies. I've created a life insurance trust that owns the policies. My wife is the primary trustee. The beneficiaries are my wife and children in successive generations. When I die someday, and hopefully no day soon, but when I die someday, the life insurance is exempt from all federal estate taxes, all state estate taxes. No 50 or 62 or 66% is going to be taken away because I don't die owning the policy. The policy is in this separate entity, the life insurance trust, and it's a very effective way to protect millions and millions of dollars of life insurance from your silent partners. So other reasons to use trusts, these entities that are very protective, in addition to avoiding all estate taxes when providing for a non-citizen spouse, like QDOT that was mentioned earlier. Sometimes there are children or other relatives that might have a special need. There are special needs trusts that can be created either while you're alive or pursuant to the terms of your will, that will provide for that individual who might have special needs. And this type of special needs trust, or also called a supplemental needs trust, the assets of that trust will not count against the beneficiary for purposes of qualifying for other governmental plans that they might qualify for. Providing support for aging parents. What if I was helping to assist my parents financially and I had a premature death and I died before them? Perhaps in my will, I can say, if my parents survive me, there's a certain amount that will be held in a trust for their benefit so that they can continue to be taken care of. And I name the trustee, for example, it could be my sister, it could be some other party, to use the funds in that trust for my parents if I indeed pass away before them and I had been assisting with regard to their care. Protecting assets from a surviving spouse's second spouse. So if you have assets held in trust for a surviving spouse, instead of going outright to them, you're ensuring that the spouse is taken care of. And you're also probably saving a great deal of taxes as well. But you're also assuring that the trust will act as a funnel to get assets down to your children and not going sideways to a second spouse or other parties that you may not want to inherit those assets ultimately. Protecting a beneficiary from others who might take their assets, kind of protecting someone who may not have the best judgment. Those assets can be held in trust, and you can have a trustee watching over those assets for the benefit of that individual. Professional management for beneficiaries who can't otherwise manage their own assets. You have the appropriate trustee taking care of those assets for them instead of, for example, making a distribution out to your nephew who may not be good with money and may be a bit of a spendthrift, as an example, and might spend it too quickly. Privacy, again, privacy is hard to come by in today's world. Trusts provide much enhanced privacy than outright distributions would. And in many cases, with regard to wealthy families, the central management of family assets, we sometimes create what are called common pot trusts. That is one trust for the benefit of multiple family members that might, for example, own a family practice or a family business or other assets for the benefit of the family, whereby we create a family constitution as to the governance of those assets and who has seats at the table to help make decisions with regard to those assets. So some year-end thoughts that you might want to consider now that we're into November. Thanksgiving isn't that far away, and once Thanksgiving comes, then we have the December holidays and the year will be at an end. Disability insurance, something always helpful to take a look at, just to ensure that any disability insurance that you or your spouse may have is up to date and that you're properly covered. With regard to bonus planning, taking into account that taxes next year will likely not be as low as they are this year. Taking typically putting on my CPA hat for a moment, the advice would be, hey, push off income into a future year, like a bonus. Push off that income so you don't have to pay taxes on it this year. You're getting that deferral. Well, you might want to take the bonus this year because the tax rates or the income tax rates are going to be lower this year than they likely will be next year. Thereby, if you take the bonus this year, yeah, you're taking it perhaps earlier than you otherwise would have anticipated, but you're paying lower income tax on the receipt of that bonus. Charitable gifting, there are more generous allowances right now for purposes of charity, whereby typically you're limited to 50% of your adjusted gross income as to what you can take for a charitable deduction. This year, because of the horrible COVID situation that the world has had to deal with, they got rid of that limit, so you can take up to 100% of your AGI as a deduction this year for contributions to charity. Funding 529 college savings plans. Funding them now with gifted assets. Well, you have a gift and a state tax exemption that's higher than it's going to be in the future. The gift planning, including transfers from non-US persons. With regard to gift planning, yes, using the big exemption while we have it is very helpful, but also if there are any participants on this call who might receive, for example, an inheritance from a non-US party that might come in from an individual who's not a US party. If that transfer from this non-US party, whether it's a parent or other relative or a friend or what have you, is transferred into the United States, the most tax efficient way in which to receive the inheritance is to have an empty shell trust here waiting to receive that large gift or inheritance, so that when the inheritance comes in or the gift comes in from this non-US party, instead of it coming to a US individual who will then own it and that gift will be subject to US estate tax or gift tax someday, if alternatively that non-US relative transfers the assets into a US trust, of which, for example, if it was for my benefit, I was the primary trustee and beneficiary, the assets coming from the non-US person going directly into a US trust will never be subject to any state or federal estate taxes. There's a form called a Form 3520 that has to be filed with the IRS whenever there's a gift coming in from a non-US party to a US party. And this is something that the IRS has been cracking down on. I have 4 new clients right now who came to us for assistance because they didn't realize that when they received gift or inheritance transfers from non-US people, that they had to file a Form 3520. And we're very fortunate. We have over 40 offices in the US, and we have a very large and robust Washington, D.C. office. And many of our attorneys in our Washington, D.C. office had previously worked with the IRS as senior counsel. So they have not only the connections, but the knowledge of the tax laws and how to deal with these types of things. So if there was any member of this call who might foresee some type of significant inheritance or gift that might be coming to them from a non-US party, number one, please ensure that you're working with your CPA or your attorney to file the Form 3520. There's a big, big penalty. For example, if there was a $1 million transfer from overseas to an individual that was not reported timely on a Form 3520, the penalty begins at 25%. So if you didn't file your Form 3520 with a $1 million transfer gift from overseas, you immediately owe $250,000. And then the IRS adds an interest component on top of that $250,000 that continues to compound and roll until you actually pay off the fine and the penalty. So we've been successful in arguing with the IRS that there was the appropriate set of circumstances, that the client was not under the understanding that they had to file this, or they received bad advice from another professional. And we've been able to successfully, in many cases, avoid this penalty. But please note, if there's a transfer from a non-US person, you have to file a Form 3520. Number two, if that transfer, whether it's a gift or an inheritance transfer, can be directed into an empty shell trust that's just waiting to receive that gift or inheritance, then you can still be in charge of that gift and inheritance as trustee and as beneficiary of this trust with no estate taxes at all for the remaining lifetime of that trust, which is very helpful, taking into account what our estate tax rates are. With regard to reporting requirements for US persons with accounts outside of the United States, the United States has always historically been concerned about US people who are subject to taxes on their worldwide income. Canada has a different tax regime. If you're a Canadian citizen, for example, you are only subject to Canadian income taxes if you're residing in Canada. I have many Canadian clients who reside in the Cayman Islands and Barbados, because if they're not residing in Canada, they don't have to pay any Canada income taxes. That's not the case with the United States. The United States, if you are a US citizen or a US resident for income tax purposes, you owe income taxes on your worldwide income. And because that's the case, the IRS and the United States government has always been concerned that is anyone hiding income out there in Swiss bank accounts and elsewhere that the US government, heaven forbid, can't tax. So there are very stringent laws, and now with FACTA, which is in essence international tax sharing information amongst governments and tax regulatory agencies, the government is finding out about a lot more of these non-US accounts, about these transfers from non-US people, and they're going after them pretty hard because the IRS can bring a lot of tax money from it. If you have a non-US bank account, you have reporting requirements other than just reporting the interest income from those accounts. There's something called an FBAR, Foreign Bank Account Return. There are other tax forms as well that you should discuss with your CPA at the end of the year to ensure that you're in compliance with appropriately disclosing these non-US accounts and taking into account the interest that would have to be paid on those accounts in your tax return. This is very high on the IRS list of what they're going after. Non-reported foreign bank accounts, non-reported foreign interests. So please ensure with your CPA that these things are being properly disclosed and properly reported. The FBAR and the other tax returns that have to be filed, the FBAR officially, the foreign bank account return, is officially a Treasury Department return. The Treasury Department is the parent of the IRS, but the Treasury Department wants its own separate reporting, and this is how serious the government takes it. The Treasury Department gets to report about your non-US accounts, and the IRS in its own separate forms, there are forms that you have to report to the IRS about particular foreign accounts. So that's how serious the government takes it, that there are two reporting agencies, the US Treasury Department, the FBAR, and the IRS itself, regarding other forms that have to be filed as well. So please do ensure that you're speaking to your advisors, NEA, and your CPA with regard to year-end issues, year-end planning. I thought what NEA said was fantastic when he mentioned that preparing your tax returns is not necessarily tax planning. And he's 100% correct. That was a very, very wise statement. Tax reporting is just saying, laying it out, saying, here it is, IRS, and here's my tax payments. Tax planning is trying to mitigate risks, mitigate taxes, and mitigate adverse issues that might arise if the situation isn't properly taken care of. So thank you. Lastly, here's my last slide. I want to thank all of you for allowing me this time in your very busy lives and on your weekend to speak with you. And thank you for the opportunity, Stanley, as well. Thank you very much. I'm happy to answer questions that you might have. And of course, my contact information is on the screen in front of you. If you'd like to reach out to me, if you have any questions, if you want to make any inquiries, please feel free to do so. But again, I thank you very much for your time. It's been a pleasure speaking with you. Thank you.
Brian, thank you very much for an excellent presentation. There's a couple of questions that were sent to me privately. For those in the webinar, you can feel free to unmute yourself and ask Brian directly, or you can send your questions in the chat. So I'm going to ask the first question that came into the chat is, does the will need to name people in the trust? Because there's a will and there's a trust. Can you kind of talk about the will and the trust? Can there be a conflict between a will and a trust?
Sure. So a will, very often, being a prospective document that only takes effect on death, will say, hold a certain amount of assets in trusts for beneficiaries. But the way that a will works is a will, in essence, is a backstop, meaning that it's the last way of disposing of assets if the assets can otherwise be disposed of in a different way. I'll give you an example. If I and my sister, for example, have a joint bank account that's owned jointly with rights of survivorship, that overrides what a will would say to do because that account takes care of itself. If we have a bank account, again, between me and my sister, as an example, that is owned jointly with rights of survivorship and I die, even though my will may say all of my assets get allocated to my wife, that joint bank account takes care of itself and goes to my sister because it's jointly with rights of survivorship. A life insurance policy. A life insurance policy has a designated beneficiary. If you designated a beneficiary, that overrides what a will would say to do. So typically what we do with regard to wills is that the will works in conjunction with the trusts and in essence directs the trust. And hopefully we don't have conflicts. But if I've created a trust during my life that holds certain assets and says what to do with those assets in the trust, and in my will, when I die, my will says to do something different, then the trust comes first and the trust controls the assets that are in it, and my will is the backup. And I hope that addressed the question, but I'm happy to try to expand on that if perhaps it didn't.
Yeah, and the other question says, can you name your trust as the beneficiary of your life insurance? Because you talked about life insurance trust. Mm-hmm. So can you name your trust as the beneficiary of your life insurance?
You can, but to get the full tax advantage, the trust would have to be named both the owner and the beneficiary of the life insurance policy. And I'll use the example of my life insurance trust that I have that I mentioned earlier in this webinar. I created a life insurance trust. Again, my wife is the primary trustee. My sister is a co-trustee in case my wife becomes incapacitated, and my wife and my children and future generations, when they come, are the beneficiaries. I don't own the life insurance policy. The designated owner of the life insurance policies in that trust is the trust itself. In addition, the designated beneficiary is the trust itself. And that way you get full tax protection. Alternatively, to address the question that was asked, if I own a life insurance policy and I direct that a trust be the beneficiary, yes, as I mentioned, the will is the backup, so the designation of beneficiary will control where the benefits go. But if I own the policy, it's still going to be subject to estate tax on my death because I owned it, even if I directed that the beneficiary is a trust. That's why, to get the full tax protection, the insurance trust should be designated both as the owner and as the beneficiary.
Okay, the next question, Brian, is there, if somebody was to join, become your new client, do you have a minimal total asset level that your firm requires for new clients? I guess, do you work with poor people?
We work with people across the financial spectrum. And some of the best clients that I have today were, and this is what the term that they've used, they were quote unquote small fries. They were years ago. But with regard to estate planning, the billionaires need more documentation than people who aren't. But we can assist people no matter where they may be along that financial spectrum, because we can help them with what they need now. Everybody, as I mentioned at the beginning of the webinar, needs the foundational 4 documents, whether you're worth $100 or $100 million. The last will and testament, durable power of attorney, healthcare proxy, and living will. If you don't have one of those documents, then no matter what your wealth may be, you're inviting the government in to be part of your plan. So we assist clients with regard to, sometimes it's only the foundational 4 because that's what they need at that time in their lives. If one has a minor child, no matter what their wealth may be, they need a will to designate, heaven forbid something happens to them and the other parent, a guardian, a backup guardian. So there is no minimum that we look at. We look at a situation, can we be of assistance to the client? And we're always happy to be of assistance to the client and have discussions with them. There's no charge for a consultation fee. If a client decides that they might not want to use us, there's no charge to have a discussion about what their needs may be. And we always give clients a solid estimate as to what fees will be so that they can make an informed decision as to how they might wish to move forward.
There is a question about, you talked about the income outside of the United States. In some instances, the person pays taxes in that other country and then pays income taxes in the US. Is that double taxation?
Typically, if there is no tax treaty between the United States and the other country that the income was earned in, the United States as a default gives credit for the taxes paid in that non-US jurisdiction. So in essence, at the end of the day, the individual who may have income, let's say it's from a bank account or a brokerage account outside of the United States where there's taxable income, at the end of the day, the US-based person, whether they're a US citizen or US permanent resident, at the end of the day is paying the higher of the 2 taxes. For example, if the tax rate in the United States was 30% and the tax rate in the non-US.
Nigeria. Just use Nigeria. Most of us are Nigerians. We have dual citizenship, and some people have income there. So how does that play?
Yeah. So in essence, whatever taxes that you pay in Nigeria are credited against what the tax would be in the United States. But in the United States, you still have to claim that Nigerian income on your tax return, and then also claim the credit for the taxes that you paid in Nigeria. And if the tax rate in Nigeria, I'm just using as an example, is 20%, and the tax rate in the US is 30%, then Nigeria gets its 20%, and the US gets the incremental 10%. If the tax rates in Nigeria were 40%, the tax rate in the US was 30%, then you get a full credit and don't have to pay the US tax. Now, states are different. If you live in a state that has its own state income tax, states that have relatively high state income taxes would be, of course, the Californias, Illinois, New York, New Jersey. My clients tend to call them the usual suspects. But states don't always give a credit, and very often don't give a credit with regard to non-US income, but very often you don't have, very often, depending upon very specific areas, you don't necessarily have to report that non-US income depending upon its source, depending upon the arrangement, if it's from real estate or what have you. But it's important to check with your CPA and to inform your CPA, because if your CPA doesn't know, they don't even know to address the issues. But with regard to your tax return, it's important to inform your CPA who prepares your tax return about all non-US accounts, all non-US income, so that you have the appropriate credit reporting, because this is a very big deal to the IRS. They're focusing on this very, very strongly, and we never want to see a client inadvertently get caught up in the issues. You know, they're not trying to evade taxes, they just didn't know the rules. That's why the disclosure to your CPA and or your attorney are very, very important.
Yeah, there's Owe raises hands. Normally this webinar is restricted to 1 hour, but there's so many questions, so many important questions. So as the moderator, I'm going to extend the time for us to get to all these questions. So Owe is a friend of ANPA. He's an attorney from somewhere in Florida, I think Miami, Florida. You can unmute yourself, Owe, and you can ask your question, please.
Yeah, good afternoon, Brian, and thank you for a very good presentation. I'm an estate planning attorney here in South Florida, and I work with a few of with ANPA members. And I would just like for you to speak to two issues. One is your counsel and advice that are tailored or that are unique to representing medical doctors or physicians, and your counsel and advice for representing or advising immigrant clients, first generation Americans that may have families in the old country. And then my third question is, or comment I'd like to make is that you described a lot of trusts, and I just want to be clear to the body that you don't walk into the lawyer's office and reel off the kind of trust that you want. It is sort of the other way around. The lawyer does an analysis of your situation and then recommends the trust that goes along with your unique circumstance. So you shouldn't have to worry about walking around knowing what a Q-dot trust is and sort of doing a shopping around for your best price for a Q-dot trust. But with that, I'll take my answers off air.
And thank you very much for the questions. With regard to physicians in particular, looking at creditor protection, looking at what their overall asset picture might be. I can prepare the most perfect will, or you can prepare the most perfect will in the world. And if all of the assets are otherwise owned in joint accounts, if all of the assets, for example, are retirement accounts that have individuals as designated beneficiaries, my perfect will isn't going to do anything if all the other accounts and other assets are taking care of themselves. As I noted before, the will is the backup. If I own a bank account in my name alone, it's not owned jointly with rights of survivorship with my spouse, my sister, or someone else, then my will disposes of that bank account. If that bank account otherwise is owned jointly with rights of survivorship, as an example, that account takes care of itself. So what is very important are the details. What does the family balance sheet look like? What are the assets? I always ask my clients for a balance sheet in 3 columns to begin the discussion. Column 1, what does spouse number 1 own? Assets, and what are their liabilities that are in their names alone? Column number 2, what are the spouse 2's assets and liabilities in their name alone? And column number 3, what are the jointly owned assets? That way we can see which assets are taking care of themselves. There's typically the jointly owned assets, or life insurance that has a designated beneficiary, or 401k plans or IRAs that have designated beneficiaries. We can change that so that it looks more like column 1 and column 2, so that each individual's will can dispose of those assets. But that's where we start, because it is a matter of digging in to the data. Again, a perfect will, if it doesn't do anything, what have we really accomplished at the end of the day? So with physicians, ensuring that we know what their plans are, what their assets are, and providing for creditor protection, not only for themselves, but for their other family members, very, very important. With regard to our immigrant clients, I work with a great number. We're an international law firm. We have offices on every continent. We're in Africa, Asia, North America, South America, Australia. We're everywhere except Antarctica, as I mentioned earlier in the call. The keys are in knowing state-specific laws. Where does the federal government, our national government, come into play here? The federal estate tax and the federal gift tax, where they would want a chunk of any transfer of too much in assets. And what is too much? It's whatever the politics of the day might happen to say is too much. So with regard to the states are really running the show with regard to who can be appointed as guardian, who cannot be appointed as guardian. I'll give you an example in the Northeast. 2 states are right next to each other. And this is very, very important for our immigrant families. Guardians for minor children. In the state of New Jersey, which is of course right next to the state of New York, state of New Jersey, you can designate anyone that you might wish, and anyone can serve as guardian, including a non-US person. Why do I say that that's important? New York, right next door, right across the Hudson River, has a different rule that most immigrant families aren't aware of, and they're not happy with when they learn about it. Because if their nuclear family had come over to the United States, and their siblings, for example, or their spouse's siblings might be back in Nigeria, for example, New York will not allow you to appoint a guardian for minor children that is not a US-based person. So you can't appoint, for example, your sister or your brother in Nigeria, where they're not a US person, not a US citizen, they're Nigerian citizens residing in Nigeria, as guardian of your minor children, because New York feels that it's it's losing jurisdiction over a minor child, and New York has a certain responsibility to take care of minors who otherwise can't take care of themselves. That's a big deal. And since New York is such a destination for so many immigrant families, when they hear this, they are not pleased about what they hear, but at least they know. So what do we do in those cases for our New York clients? We do a dual appointment for guardians in their wills. We say that, for example, the Nigerian sister, who's a Nigerian citizen, Nigerian resident, is a co-guardian with some US person that the family chooses. It might be a friend, and we all know that if heaven forbid something happens to both parents, God forbid something happens to them, we have minor children who need to be taken care of, we know that it's really the sister in Nigeria who's going to be the primary caretaker, but layering on that US friend or other US relative or US contact as co-guardian allows us to shoehorn in a guardian, if you will, for lack of a better term, that otherwise would not be allowed to be appointed under New York law. So some of these state-specific laws are very important to know. In addition, as I mentioned earlier, where we don't have US citizen spouses, you can't make unlimited transfers for gift and estate tax purposes. So there are limitations with regard to what you can do with regard to transfers. The Q dot trust that I mentioned, where a non-US citizen spouse can benefit free of any estate taxes using this Q dot structure, that's only for bequests on death. You can't use Q dots for lifetime transfers. Many people who may have heard of Q dots or did some research about them don't realize that. So these are important aspects from a tax point of view, but also, I think, in my opinion, just guardian of minor children. Those are the most important decision anyone can make. Just knowing what the rules are in your state is incredibly important. And some of the rules are not intuitive. You would think that, heck, if I was an immigrant family and my wife and I both passed, that we can have our my sister-in-law in Nigeria be the guardian, because it's the closest family member that minor child would have. New York doesn't see it that way.
Okay, thank you, Brian. There's a few more questions for you. Do you take clients who are not residents of your state? And is it advisable to work with an estate planning firm located in your own state, since the laws of the states are different, or does it matter?
Yeah, so we have 40 offices throughout the United States, so we are not everywhere. We're in very many places, and the Danton's map continues to expand. But generally speaking, with regard to an estate planning attorney, you are looking for an estate planning attorney who practices in your jurisdiction or is licensed in your jurisdiction. For example, we have offices in Kansas City, Missouri. Kansas City, Missouri is right next to the state of Kansas. But we have estate planning attorneys in Kansas City, Missouri, who are licensed and may even live in the state of Kansas. So if you have someone who's licensed in the jurisdiction and or practicing in the jurisdiction, that's helpful. And in other jurisdictions where we may not have an office, sometimes things are so complicated for that family at the federal estate tax level that we will work in conjunction with local counsel, so that we have kind of the national or international expertise, but we'll work with local counsel. I'm doing that right now with a very wealthy family in Oklahoma, for example. We don't have an office in Oklahoma, but we have a very wealthy family based in Oklahoma City, whereby one of the family members is marrying a non-US person. Now that brings into account, well, what does an international prenuptial agreement look like? What are international ramifications are there? So we are working hand in hand in a very good partnership, in a very good way, with local counsel, who is certainly more knowledgeable about Oklahoma law than we are, whereby we can bring to the table the value of our international experience.
Speaking of prenuptial agreements, if most of your assets are in a trust from your own family, I guess whether prenuptial or not, the assets are protected from divorce anyway, correct? If it's in a trust for you.
In a properly prepared trust, yes. The trust will provide divorce protection, will ensure that those assets within the trust remain separate assets, separate property. As I mentioned a bit earlier, separate property does not get divided in the event of a divorce. Marital property does get divided. So just as an example, when my wife and I got married, I think collectively, because of her student loans and my very low net worth, we had a negative net worth 26 years ago when we got married in the early 20s. So number one, I would have had to sell my car to afford the prenuptial agreement. And if I sold my car and paid for the prenuptial agreement, there would have been nothing to fight over. So I don't have a prenuptial agreement. But with regard to, as an example, my wife and I have both worked during the period of time of our marriage to have what we have now. We have a house, brokerage account. We have certainly more in assets than we did 26 years ago when we first got married. All of our assets would be, if my wife decided, walked in right now and said, Brian, I want a divorce, I'm out of here. All of those assets that we earned together through our work product during our marriage would be considered marital assets, or what we call marital property. And a judge would probably say, hey, you two have been married for 26 years, you had nothing when you got married, and now you have something. We're just dividing that 50-50. Alternatively, if I received a large inheritance, which isn't happening, but if I received a large inheritance from my parents, and I segregated it in its own account, that's considered separate assets, separate property, not subject to division in the event of a divorce, but it's much, much better if those assets are held in trust instead of me just trying to segregate them over in a different account. Because if I take an inheritance from my parents and put it into the joint account I have for my wife, I take it outright, and if I'm using it for family purposes, even if it's in a separate account, now through the process of what we call transmutation, that separate asset character is transmuted and the separate assets become marital assets. The trust preserves the separate property nature of the assets so that in the event of a divorce, the trust in essence is already acting as a prenuptial agreement.
Brian, thank you very much for your time and excellent presentation and feedback and answers and everything. Amy, do you have any closing comments?
Sure, thank you very much. Listen, fellows, thank you again for a very spirited, hopefully educational session for you. The takeaways here are, it's really about expertise. You need experts who know and understand what the laws are. Just like Owe said, you can't just walk in. It's just like having somebody come to you and say, I need Panadol or whatever it is that they need for whatever they think they're ailing. So you need experts, people who know and who are going to take you through the process of understanding what solutions they need to provide you. And that's where this comes in. And they need to be coordinating or interacting among themselves. The lawyers, the estate planning attorneys need to be talking to your CPAs and so that if there are any tax documents and things like that need to be crafted and filed, that those things are done also. This is where, again, the interaction comes in amongst your advisors. So we hope that this has been helpful. We ask you if you have any questions, you can certainly reach out to us or you can reach out to Brian, and feel free to go to ANPA, welfareexpertdoctors.com/ANPA. There's some downloadable white paper there. Actually, one of them is about not practicing law, the legal practice of law, and a few other articles there that hopefully will be beneficial to you. Look forward to seeing you next month. It's the end of the year. We have one more webinar looking ahead next month. And next month, we're actually going to do a last-minute tax planning for your practice, those of you who have your own private practice, and for you personally. We're going to be in the last few days of the year. So everything we're going to do will be focused on that. And then in January, we're going to start with the subject of risk management. Risk management incorporates some of the things that Brian talked about, asset protection, disability, and so on and so forth. You're going to start with looking at risk in the context of the new year and then planning those kinds of things. And then beyond that, we will, on a monthly basis, kind of keep you appraised of what will be coming in the next few months. We would like you to give us some feedback on how this is serving you and how we can improve on what we're providing you. So we thank you for your time. We thank you for indulging us, and we'll be committed to providing you excellence and a professional team that will hopefully meet your needs as you go forward. Thanks, Stanley.
Thank you, Amy, for your service to ANPA. Thank you, Brian. We really appreciate your time and everything done to ANPA. The next webinar is December 5th. The webinars are the first Saturday of every month at 12 noon. We will always respect your time. We will start exactly at 12 noon, and we plan to stop at 1 hour, but today was so much questions, we extended it for 25 minutes. Thank you very much. If you have any questions, please feel free to reach out to our presenters, either Amy at wealthrxfordoctors.com or Brian has listed his email here. I wish everybody have a wonderful, wonderful weekend. This is a very exciting weekend. I think we're gonna have a new president-elect, whichever party you'll go with, but I think democracy is at work. Thank you, everyone. Have a wonderful weekend. Bye-bye. Is Chris still here? I think he's gone. He has other meetings. So thank you, ANPA president, for allowing us to do this. Have a wonderful day, everyone.
Thank you.
Thank you.